All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2018 English version.
Please be seated. I beg your pardon. Welcome everybody. Good afternoon. I would like to greet the teams of the counsel for Mr. McGregor Clegane, the counsel for the prosecution, and the counsel for the victims. I welcome also the courtroom staff, the security officer, who of course always diligently assist us in our work, and of course the members of the public who are seated in the public gallery, as well as all of the other participants to the ICC Moot competition who are attending this hearing, and those who are joining us as we are also being streamed via the internet. I would like now to ask the court officer that she call the case, please.
Thank you, Mr. President. We are sitting in an appeals session regarding the defense of Mr. McGregor Clegane against the pretrial chamber decision on the confirmation of charges of other inhumane acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health under Article 7K of the ICC statute. Crimes were allegedly committed in the context of the situation in Westeros, ICC Moot Court Competition 2018 English edition.
On behalf of the chamber, I would now like to ask the parties and the participants to introduce themselves, beginning with first the counsel for the defendant. But before I do, as we are being recorded, and as always is good practice as advocates, which you will all be soon, I would invite you to take your time, speak slowly, clearly, and pause before responding when you actually begin your submissions. Good. So, counsel, could I ask you to present the members of your team for the record, please?
Honors. Mr. President, Your Honors, my name is Lee Chuan, spelled Leechuan, and I'm gratefully assisted by my co-counsel, Ms. Tracy Ghani, spelled Gani. May it please the court.
I'll turn to counsel for the prosecution. Can you do likewise for the record?
May it please the court, my name is Gemma McLaughlin-Burke, and I appear alongside my co-counsel, Ms. Sarah O'Malley.
Thank you. And counsel for the victims, can you kindly also for the record introduce your team?
Good afternoon, Your Honors. My name is Vinayak Chawla, and I'm assisted today by my co-counsel, Ms. Pramiti Parvani. We represent the victims today before this court.
Thank you. The team of the registry is represented today by the court officer, Rosaline Jimenez, and Miss Sophie Mercer and Mr. Shreya Agarwal from the Goethe Center for International Legal Studies. Finally, I would like to introduce the bench. To my right is Mr. Anthony Abato. To my left, Ms. Namita Singh. And I am Judge Jeffrey Henderson, and I will be presiding this afternoon. The Chamber will now proceed to hear consecutively the three issues that shape the subject matter of today's hearing. Being mindful that this is in fact a public hearing, I would invite the court officer to please read the agenda established by the pretrial chamber.
Thank you, Mr. President. This case arises out of allegations of crimes against humanity committed on the territory of Westeros to the west, bordering the Foamy Sea, Northeros to the north, and Southeros to the south. Of the three, only Northeros is a party to the Rome Treaty, ratification deposited in 2003. This case arises under the ICC's nationality jurisdiction since the defendant is a national of Northeros. First, at the request of the prosecutor on the 25th of May 2017, pursuant to Article 57 of the ICC statute, the ICC pretrial chamber authorized an investigation, and on the 2nd of July 2017, pursuant to Article 38, the ICC issued a warrant for the arrest of the defendant, Mr. McGregor Clegane of Northeros, for involvement of the crime against humanity of human trafficking under Article 7K, Article 25.3, and Article 28B of the ICC statute. Second, on the 3rd of July 2017, the pretrial chamber appointed a common legal representative to serve as a counsel to the Southeros victims under the Article 68 of the statute. And on the 10th of July 2017, Northeros took Mr. Clegane into custody and transferred him to the ICC, which immediately appointed him defense counsel pursuant to Article 55 of the ICC statute. The appeals chamber seeks submissions of all parties and participants on the following issues. A, whether the ICC should recognize human trafficking as set forth in the facts described in the pretrial chamber's decision as qualifying as other inhumane acts of a similar character, intentionally causing great suffering or serious injury to body or to mental or physical health under Article 7K of the ICC statute. B, whether a corporate subsidiary that purchases shrimp at an extremely low price from the Westeros shrimp sheds with knowledge of the labor abuses can be treated as an unindicted co-perpetrator for purposes of prosecuting the defendant under Article 25.3a of the statute, notwithstanding Article 25.1 of the ICC statute. C, whether a domestic court acquittal of the defendant based on an erroneous interpretation of the ICC statute's definition of crimes against humanity under circumstances of this case shall preclude the ICC from prosecuting the crime under the nebis in idem principle enshrined in Article 20 of the ICC statute.
Thank you, Madam Court Officer. I will now give the floor to counsel for the defendant to present its case and to discuss the three issues that arise on these papers.
Mr. President, Your Honors, may it please the Court. Your Honours, the present case concerns the prosecution of the wrong man for the wrong crime. While we recognize the importance of stopping labour exploitation around the world, as a creature of the Rome Statute, this court must ensure that the concept of crimes against humanity is judiciously applied, that the jurisdictional limits of this court is not extended in an unprincipled manner, and that the principle of complementarity, which underpins the consent of state parties, must be respected. And in this regard, the Defence Counsel humbly praised this court to dismiss the charges on 3 alternative grounds. First, human trafficking, as set forth on the facts, does not qualify as a crime against humanity under Article 7.1k of the Rome Statute. Secondly, Littlefingers cannot be treated as a co-perpetrator for the purposes of prosecuting Clegane. And thirdly, the present case is not admissible before this court, given that Clegane has already been tried and acquitted by the North Wales District Court. Pursuant to Article 20, Paragraph 3, the present case is not admissible. Your Honours, I'll now turn to my first submission. Human trafficking, as set forth in the facts, does not qualify as Article 7.1k crime against humanity. We say so for 2 reasons. First, as a matter of law, human trafficking cannot be recognized as an independent crime against humanity under Article 7.1k. Secondly, on the facts, the objective element of great suffering or serious injuries has not been made out. Your Honours, turning to my first argument, if I may refer Your Honours to Article 7.1k as found on page 4 of the Rome Statute, Article 7.1k prescribes the crime of, and I quote, other inhumane acts. The operative word other indicates that Article 7.1k is a residual category of crimes against humanity, and as clarified by this court in the ongoing confirmation of charges decision at paragraph 92, in order for an act to be recognized as an independent crime under Article 7.1k, it must entail a notably different protected interest from the existing crimes against humanity. Your Honours, today we submit that human trafficking does not entail a different protected interest, and that the difference lies only in terms of the degree of exploitation, with human trafficking entailing less serious forms of labour exploitation that falls outside of the crime of enslavement under Article 7.1c. If I may refer Your Honours to the definition of human trafficking as defined under Article 3a of the UN Trafficking Protocol, it refers to the recruitment, transportation, or harbouring of persons by means of coercion for the purposes of exploitation. Now, in the present case today, the prosecution argues at page 19 of their written submissions that the South migrants were trafficked for the purposes of forced labour. However, situations of forced labour that are serious enough to amount to crimes against humanity has already been envisaged by the drafters and prescribed under the crime of Article 7.1c, enslavement. And this is clarified under footnote 11 of the elements of crime.
Counsel, if I can stop you, doesn't that hurt your argument though? If trafficking in persons is covered under 7.1c, then obviously it would have the proper nature and gravity to be included within the jurisdiction of the court?
No, Your Honours, our primary position is that the present case does not amount to enslavement under Article 7.1c, neither does it amount to crimes against humanity under Article 7.1k. We note that the prosecutor and the victim's representative have similarly conceded that the present case does not amount to Article 7.1c, enslavement. Now, this is because enslavement requires a degree of permanence, as clarified by the ICTY case of Quinarec by the Appeals Chamber. Now, the present case, it is a voluntary working arrangements of 3 years, which would not amount to that threshold. Now, therefore, even though the prosecutor and the victim's representative have conceded that the present case does not amount to enslavement under Article 7.1c, they nonetheless argue that the crime that Clegane can be prosecuted under Article 7.1k by recognizing human trafficking as an independent crime against humanity. However, Your Honours, this was something that was precisely rejected by the drafters of the Rome Statute. During the drafting of the Rome Statute, the Women's Caucus had proposed for the crime of human trafficking to be recognized and included as a distinct crime against humanity. And this was noted by Professor Trifterer in his 2016 Rome Statute commentary at page 262. However, this proposal was not adopted by the drafters. Instead, the drafters had only intended for human trafficking where it rises to the level of severity to amount to crimes against humanity to be subsumed under the crime of enslavement under Article 7.1c. If I may refer your honors to Article 7.2c, which defines enslavement, it includes the exercise of power of ownership in the course of trafficking in persons. Now, therefore, we submit that given that the drafters have directed their mind both to the trafficking process as well as the exploitative acts of forced labor, and only saw it fit to prescribe it under the crime of enslavement under Article 7.1c, we submit that allowing the prosecution to proceed under Article 7.1k when they cannot meet the threshold of Article 7.1c would be tantamount to a dilution of the concept of crimes against humanity. Now, Your Honours, I'll turn to my second argument, which, even if this court recognizes human trafficking as a matter of law, as a distinct crimes against humanity, the employment arrangements on the facts did not cause great suffering or serious injuries to the Salvador's migrants. Now, this is detrimental to the prosecutor's case because great suffering or serious injury is an objective element under Article 7.1k. The prosecution, as stated in page 22 of their written submissions, relies on three primary facts to show that there are great suffering. And these facts are, firstly, that the Salvador's migrants had contracted to work for a period of 3 years, and during the period of 3 years, they will not be able to return home. And the second fact relates to the retention of the passport and 80% of their salary. And the third point relates to the long working hours of the migrant workers. However, Your Honours, even if we take these facts cumulatively, they do not indicate that the migrants had been subjected to great suffering or serious injuries. In relation to the point that they cannot return home for 3 years, this court must note that the working arrangements and the contractual terms were ultimately voluntarily accepted by the Salvador's migrants. And Your Honours, this is stated on page 4, paragraph 7 of the Westeros trial court's decision. Notably, the facts in the present case have not shown that the Salvador's migrants have been deceived as to the terms of the contract or deceived as to the terms, the nature of the work that they had signed up for. Furthermore, on the facts, it is also silent that the Salvador's migrants were physically abused by their employers. Now, none of these facts are present.
Counsel, a question about this decision of the Westeros trial court. Is such evidence admissible before this court, and if so, what weight should be attached to it?
Your Honours, we note that at the confirmation of charges stage, this court can rely on summary evidence, and we are not challenging the admissibility of the Westeros trial court decision. Rather, we are challenging that even accepting the judgment of the Westeros trial court and all other available facts, there is simply a paucity of evidence that does not satisfy the threshold in showing that there has been great suffering or serious injuries caused to the Salvador's migrants. Now, Your Honours, even if we accept that the terms were unfair to the Salvador's workers, that perhaps the Salvador's workers should have been paid more or required to work for lesser hours, this court must recognise the huge gap between labour law violations and difficult working conditions on the one hand, and the most heinous crime of crimes against humanity on the other. This court was not established to try every instance of labour law violation, and we submit that in light of the paucity of evidence showing that there has been great suffering caused to the Salvador's victims, it is prejudicial to my client to charge him under the most heinous charge of crimes against humanity. Your Honours, not only has the pretrial chamber diluted the concept of crimes against humanity, the pretrial chamber has also extended this court's jurisdiction to crimes committed by corporate entities, and this brings me to my second submission. In treating Littlefingers as an unindicted co-perpetrator, the pretrial chamber has committed both an error of law as well as an error of fact. Now, firstly, as a matter of law, treating Littlefingers as a co-perpetrator, even where Littlefingers is unindicted, breaches the principle of individual criminal responsibility as enshrined in Article 25(1) of the Rome Statute. And my second argument relates to the factual argument that the purchase of shrimps at low prices does not render Littlefingers as a co-perpetrator and does not give Littlefingers control over the crime. Your Honours, I'll turn to my first argument. Article 25 enshrines the principle of individual criminal responsibility. And the principle of individual criminal responsibility reflects the long-standing understanding under international law that crimes under international law, criminal law, are committed by men and not abstract entities. And this was held by the ICTY Appeals Chamber in the Tadic Appeals on Jurisdiction decision at paragraph 128. Now, therefore, we submit that Article 25, paragraph 1, especially when read in light with the preparatory materials, show that Article 25(1) is violated when treating Littlefingers as an unindicted co-perpetrator for the purposes of prosecuting Clegane. The difficulty before this court is that in treating Littlefingers as a co-perpetrator, this court would have to adjudicate on whether a company had committed a crime. This court would be seized of issues relating to corporate criminal liability, such as whether Littlefingers possessed the intention to cause great suffering and whether Littlefingers had made an essential contribution to the crime. Now, it is for this very reason that it was the consensus of the state parties to reject the concept of corporate criminal liability in its entirety. Now, if I may refer your Honours to the preparatory materials, as found on page 135, paragraph 50 of volume 2 of the preparatory materials, it states, and I quote, that many delegations had difficulty in accepting any reference to legal persons in the Rome Statute, end quote. And this was noted by the chairman of the Committee of the Whole during the Rome Conference. And therefore, even where Littlefingers is not subjected to indictment or punishment, this court will still be seized of unresolved difficulty of how to attribute mental and objective elements to Littlefingers when this court applies Article 25(3)(a) directly to a legal person. And it is on this basis that state parties have expressly rejected the concept of legal persons within the Rome Statute, and this court should give effect to the consensus of the state party and ensure that Article 25, paragraph 1 is not breached. Your Honours, this brings me to my second argument. Even if this court, as a matter of law, can treat Littlefingers as an unindicted co-perpetrator, on the facts, the purchase of shrimps at low prices does not render Littlefingers as a co-perpetrator of crimes against humanity. Co-perpetration under Article 25(3)(a) is a principal mode of liability and not an accessorial mode of liability. And as clarified by the Lubanga Confirmation of Charges decision at paragraph 341 and the Katanga Confirmation of Charges decision at paragraph 486, this court clarified that the concept of co-perpetration is premised on the control over the crime approach. Now, namely that co-perpetrators are principally liable for the crime due to their control over the crime by reason of the essential tasks assigned to them. Now here, the impugned act of purchasing shrimps at low prices does not give Littlefingers control over the employment conditions of the Saudos migrants. Now, hypothetically, even if Littlefingers had bought the shrimps at a higher price from the shed operators, there is no guarantee that the higher prices paid to the shed operators will be translated to better employment arrangements and better employment terms for the Saudos migrants. And even if Littlefingers had stopped purchasing shrimps from the restaurateurs altogether, the shed operators would still retain control over the Saudos migrants by virtue of the 3-year contractual term of the employment. Now, given that Littlefingers and Clegane did not have any control over the crime and over the employment conditions of the Saudos migrants, the key element of essential contribution is not made out, and therefore we say that on the facts, Littlefingers does not satisfy the elements of co-perpetration. Your Honours, I now turn to the issue.
Counsel, sorry,
Yes, Your Honour.
I have a question for you on that point. But the fact that Littlefingers was responsible for buying 60% of the shrimps, don't you think that might have contributed in an essential manner to maintaining the state of affairs?
Your Honours, I note that as a major buyer and a market leader in Westeros, Littlefingers could have done more by, for instance, bringing shrimp processing in-house. But however, even if they brought a new group of workers in-house for shrimp processing, Littlefingers would still not have control over the victims that are employed by the Stalderos shrimp operators. We note further that in line of best business practices, Littlefingers could have done more. But the failing to act in best business practices should not render Littlefingers principally liable for the crime. Now, the question before this court is not what more could Littlefingers have done. The question before this court is whether the act of buying shrimps gives Littlefingers control. While we note that more could be done, we submit that the act of buying of shrimps is not sufficient to render control over the crime and render Littlefingers as a co-perpetrator of the crime. Your Honours, with this, I turn to issue 3 of the appeal. And this relates to the issue of admissibility, which is an important issue, because even if this court possesses the jurisdiction over the case, the prosecutor must still show that the present case is admissible before this court. And the article in question here is Article 20, Paragraph 3, which provides that an individual who has been tried by another court shall not be tried by this court with respect to the same conduct. The ne bis in idem principle, as enshrined under this provision, serves 2 primary purposes. Firstly, it protects the individual from subsequent and repeated trials over the same conduct. And more importantly, it also serves the principle of complementarity, as found under Article 1 in the preamble of the Rome Statute. Now, we note that it is not in contention as to whether Clegane has been tried over the same conduct, but the key contention before this court is whether an error of law allows the ICC to intervene and whether the exception of bias has been invoked in the present case. Turning to my first point in relation to an erroneous error of law, we note that the prosecutor has argued at page 40 that an error of law will allow the ICC to intervene. Your Honours, the alleged error here is found at the last sentence of page 5 of the North Wales District Court's decision, and it states that Judge Nefarious had ruled that the employment arrangements constituted human trafficking but do not constitute crimes against humanity. Now, we note that what the prosecutor and the pretrial chamber has characterized as an erroneous interpretation is, in effect, a contrary interpretation from what the majority in the pretrial chamber and the prosecutor is arguing for. Now, we submit that allowing a second trial whenever the ICC disagrees with the domestic court would render the principle of complementarity completely unworkable. It will transform the ICC from a complementary court exercising secondary jurisdiction to a supervisory court exercising appellate jurisdiction. Now, this is
But counsel, my interpretation of that district court ruling is that it was strictly on jurisdictional grounds, that it wasn't actually a trial to completion, and there wasn't essentially an acquittal on the merits of the case. It was a finding of no jurisdiction. So how does that actually become binding on the ICC, and why wouldn't the ICC be able to exercise?
Your Honours, we submit that the decision was on the merits and it relates to the facts and not just the jurisdiction. In relation, we note that there are 2 charges in relation to the charge of human trafficking under the North Wales Human Trafficking Act. That might amount to a technical acquittal, given that it does not have extraterritorial application. But on the crime of crimes against humanity, Judge Nefarious, as stated at the last sentence of page 5, considered the facts as described in the Westeros trial court judgment and held that on the facts, it constituted human trafficking but did not constitute crimes against humanity. While we note that there is no further reasoning, but this could be due to the fact that elements such as great suffering has not been made out on the facts. Now, therefore, we submit that if Your Honours, I note that my time has expired. If I may be permitted 1 minute to conclude the submissions on bias.
Yes, leave is granted.
Much obliged, Your Honours. Your Honours, turning to the issue of whether Article 20, paragraph 3b has been engaged, we note that the ICTY Appeals Chamber of Rinja has noted that there is a high presumption of bias given to judges, and that on the facts, the newspaper article as found on page 8, paragraph 1c of the findings and conclusion is not sufficient to rebut that high presumption. Even if we accept that the newspaper article was accurate, all the newspaper article said was that Clegane had donated to a former president of Northeros, and that there is simply nothing on the facts to suggest that Judge Nefarious had been influenced by Clegane in rendering his judgment. Unless I may be of further assistance to this court, this concludes the defense's submissions. May it please the court.
Thank you very much. I will now turn to the prosecutor to present, Madam Prosecutor, to present your submissions on these issues, which the Chamber would wish to hear from you.
Mr. President, Your Honours, may it please the Court. Article 5 of the Rome Statute states that the ICC can only prosecute the most serious crimes. Human trafficking is not only a serious crime, but has grown into a global corporate criminal industry, with victims of trafficking now estimated in the tens of millions. It is the submission of the prosecution that human trafficking can only be effectively prosecuted if it is recognised as a distinct crime against humanity in its own right, if corporations can be held to be unindicted co-perpetrators, and if this court can intervene where national courts have failed to adhere to norms of judicial impartiality. To that end, I will submit in relation to each of the 3 grounds of appeal. First, that human trafficking can and should be held to be an other inhumane act pursuant to Article 7(1)k. Second, that Little Fingers Incorporated can be held to be an unindicted co-perpetrator, as this court will not be exercising jurisdiction over them. And third, that this court can continue to prosecute the defendant in circumstances where the national proceedings lacked the requisite judicial impartiality required. Turning to the first ground of appeal, this relates to whether or not human trafficking can be considered to be an other inhumane act. And the court will note from paragraph 4, subparagraph 5 of the pre-trial chamber's confirmation of charges that approximately 10,000 South citizens were recruited from their homes and transported to the Westeros shrimp sheds, where they were thereafter exploited. I have 2 submissions to make on this ground. First, that human trafficking is not already subsumed within the crime of enslavement and can be considered to be an other inhumane act. And second, that all of the limbs of the test set out in Article 7(1)k are met in the present case. Turning to my first submission, counsel for the defence correctly highlighted the test that has been applied by this court in the Ongwen decision by the pre-trial chamber. And that is, as stated at paragraph 2, that there is a difference of conduct, harms, and protected interests. Human trafficking has been defined in the Palermo Protocol as being the recruitment, transportation, transfer, receipt, and harbouring of persons for the purposes of exploitation. Enslavement, as defined in the Rome Statute at Article 7(2)c, is concerned with the exercise of the powers of ownership over persons. In comparing the conduct between those 2 crimes, it is clear that there are certain links in what the prosecution submits is a chain of exploitation of human trafficking, which simply do not fall under the crime of enslavement. For example, persons who are recruited by individuals for the purposes of human trafficking have no powers of ownership exercised over them. And so that is a distinct element of human trafficking which falls outside of the remit of enslavement. And I note that counsel for the defence submitted that the prosecution have conceded that there is no enslavement in the present case. That is not our position. In fact, the prosecution submits to the court that although we recognise there are instances of trafficking which are enslavement, trafficking also has elements which fall outside of the definition of enslavement. And the only way that this court can effectively prosecute that crime is to recognise the crime as a whole, including the 5 links of that chain of exploitation. In relation to my second submission, it is the submission of the prosecution that all of the elements of Article 7.1k are met in the present circumstances. I don't propose to address each limb. I note that counsel for the defence has raised the issue of suffering, and so I propose to address that particular limb. But if the court has a further limb it wishes for me to address, I am happy to do so. In relation to great suffering, counsel for the defence submitted that there simply is not sufficient evidence in the present case that there has been great suffering on the part of the South Eros victims. The prosecution submits that in fact in circumstances where great suffering has been defined in the Christich decision by the ICTY as not having the necessity of being permanent or irremediable, but merely needs to go beyond temporary unhappiness or humiliation, that standard has been met. On the facts of the case as set out in paragraph 4, subparagraph 6 of the pretrial chamber's confirmation of charges, it is clear that these persons were not entering into a standard employment contract. They worked 80 hours a week in labour-intensive conditions. They had their identification and transportation documents taken from them. They could not leave. They lived in isolated, rustic camps beside those shrimp sheds. It is the submission of the prosecution that those facts, coupled with the fact at paragraph 3 of the pretrial chamber's confirmation of charges, wherein it stated that during the civil proceedings over 1,000 pages of evidence were submitted during the course of that trial, that it is the bar in relation to great suffering is met in the present circumstances. And so all of the limbs in the prosecution submissions have been fulfilled. Unless the court has any further questions in relation to that ground, I propose to move to my second ground of appeal.
It's really the second one. I really wish to hear you on.
Excellent, Mr. President.
And I need to be persuaded on.
In that regard, the prosecution submits that Little Fingers Incorporated can be held to be an unindicted co-perpetrator for the purposes of prosecuting the defendant. The court will note that this issue arises out of paragraph 4 of the pretrial chamber's paragraph 3 of the pretrial chamber's confirmation of charges, wherein Little Fingers Incorporated is described as being a Westeros corporation. Counsel for the defence submits that the use of this unindicted co-perpetrator, as it is a corporation, would be a violation of the Rome Statute. It is the submission of the prosecution that we are not seeking to further the jurisdiction of this court and extend it to corporations. In fact, all we are seeking to do is to use this as a mechanism by which to prosecute the defendant. And this unindicted co-perpetrator mechanism has been used by this court in Bemba and also by the ICTY in decisions such as Gotovina and Vasilyevich. And most notably in the Vasilyevich case, the court noted at paragraph 23 that any findings made against the 2 unindicted co-perpetrators were made for the purposes of that trial and that trial alone.
Can I ask you, counsel, in that case, was it also the case that the court didn't have jurisdiction over those unindicted co-perpetrators?
Yes, Your Honour, that was not the case. In fact, the 2 unindicted co-perpetrators were persons. However, the prosecution submits that that principle still applies. That principle being that although findings were made during the course of that trial, those persons still retained their presumption of innocence. None of the findings made during the course of that trial were binding on those unindicted co-perpetrators. And so in similar circumstances, where any findings by this court will not be binding on Little Fingers Incorporated, it cannot be said that this court is exercising jurisdiction over a corporation. And the prosecution also submits that it's quite clear from the Rome Statute that this court, for example, cannot exercise jurisdiction over those under the age of 18. However, in the Bemba case, the court was able to consider the conduct of the defendant and other child soldiers for the purposes of assessing the liability of the defendant. And again, that is the principle we're seeking to apply in the present case. We are not seeking to have any liability attributed to the corporation, but merely to view the behaviour of the defendant through the lens of that corporation. And that moves me to my second submission under this particular ground, that being that the test for co-perpetration is met in the present circumstances. And as counsel for the defence outlined, there are both objective and subjective elements to this test, and there are 8 limbs of the test for co-perpetration, one of which the defence has laid emphasis on, that being the essential contribution of the defendant. The court will note from paragraph 5 of the pretrial chamber's confirmation of charges that the defendant and Littlefingers Incorporated purchased over 60% of the shrimp that was being exported from Westeros. And an essential contribution need not be the control over the conditions of the workers in question. In fact, it was stated in the case of Lubanga at paragraph 1003 to 1005 in the pretrial chamber that an essential contribution can also involve the controlling mind behind the actions of a particular conduct. And so in circumstances where the defendant and Littlefingers Incorporated were the controlling minds behind this conduct, those persons can be held to be co-perpetrators and to fulfill the test for co-perpetration. Yes, Mr. President.
Where do you get this evidence or this material that they were the controlling mind?
That can be found in the pretrial chamber's decision, and it's noted in paragraph, I believe, 5 of that decision. Just the third paragraph into that page, it states that under Giant Finger's corporate structure, Clegane had the ultimate authority to disprove and block the corporate actions of Littlefingers and supervisory control over Littlefinger's executive officers. And counsel for the defence laid great emphasis on the fact that the actions of the defendant were not controlling the conditions within the shrimp sheds. However, it is not those actions that this court has to take into account, but in fact, the control of the market in question are the actions that this court has to take into account, because the actions of the co-perpetrators need not be criminal in nature itself. They need only involve the possibility that there will be criminal conduct as a result of their actions. And in circumstances where both the defendant and Littlefingers Incorporated, at the very least from 2015, when the media reports surfaced in relation to the abusive labour practices, had a knowledge of those abusive labour practices, it was open to them to either withdraw from purchasing the shrimp from the independent shrimp sheds, or perhaps more practically, to insist on better labour practices within those sheds, or to risk the withdrawal of their financial contribution to those shrimp sheds. And so in that regard, it cannot be said that they had no essential contribution to the conduct in question. The prosecution is firmly of the view that this contribution is the reason that this conduct continued until 2017, when these proceedings began. And I'm not sure if the court wishes for me to address any of the additional elements of co-perpetration. I propose to address just one final limb of the test for co-perpetration, that being the intent requirement. And I am addressing this limb in response to counsel for the defence stating that there was no intention present in relation to the conduct in question that was carried out in these shrimp sheds. In relation to intent, this has been assessed by the trial chamber in Lubanga at paragraph 1007 as involving conduct, consequences and circumstances. As previously submitted, the conduct in question was the continued purchasing of this shrimp after the knowledge of those abusive labour practices arose. The circumstances relate to the to the abusive labour practices as demonstrated in the media reports and the immense financial profit that the defendant and Littlefinger's were making as a result of those practices. And the consequences can be assessed when the court has regard to the fact that the continued purchasing of the shrimp at this price was leading to those continued practices. And the court can assess this intent on the basis of both the defendant and the executives of Littlefinger's Incorporated who were responsible for the running of that company. And so in those circumstances, the prosecution submits that the intent element of the test for co-perpetration has been met in the present circumstances. I might move to my final ground of appeal, and that relates to whether or not this court can continue to prosecute the defendant in circumstances where national proceedings have already occurred. And this arises... Yes, Your Honour.
Before you move on to the last
Yes,
round,
Your Honour.
could you briefly address whether the court can consider the accused's responsibility under Article 28 of the Rome Statute?
Yes, Your Honour. This was an issue which came before the pre-trial chamber and in fact has not been appealed by the defendant. However, it is necessary for this court, as per the trial chamber decision in Bemba at paragraph 402, to first consider whether or not co-perpetration as per Article 25 has occurred before it can consider the co-perpetration under Article 28. And so in those circumstances, if the court does not find that the requisite test in Article 25 3A is met, they can continue to prosecute the defendant under Article 28B. Turning to my final ground, which relates to the national proceedings which have occurred and the defence's contention that continued prosecution of the defendant is a breach of the principle of complementarity. The prosecution would submit that as contained in paragraph 5 of the pre-trial chamber's confirmation of charges and in the findings and conclusions set out in paragraph 1C of that document, that two issues have arisen in relation to impartiality, those being the relationship between the defendant and the trial judge and the erroneous interpretation of the Rome Statute. And counsel for the defence contended that on the basis of what he described as a misapplication of the law, we were seeking to have this court exercise appellate jurisdiction. In fact, it is the submission of the prosecution that the relationship between the defendant and the erroneous interpretation themselves can be considered to be a lack of impartiality. The standard on which to assess impartiality, as set out in the Bemba case, is that of a reasonable observer properly informed. It is the submission of the prosecution that a reasonable observer properly informed would apprehend bias in circumstances where there was a connection between the defendant and the trial judge, and the court will note that that is the millions of dollars contributed to the president who subsequently elected that judge, alongside the erroneous interpretation of the Rome Statute. And the erroneous interpretation of the Rome Statute is illustrated by the fact that during the course of that trial, the trial judge found as a matter of fact that human trafficking had occurred. The trial judge applied the Implementation Act of 2003, which directly translates the wording of Article 7 of the Rome Statute. In the Rome Statute, at Article 72C, trafficking is denoted as being an example of enslavement. However, the trial judge went on to find that human trafficking did not amount to a crime against humanity. And though, admittedly, the prosecution and defence are at odds as to where to place the crime of human trafficking within Article 7 of the Rome Statute, it is undoubtedly still contained in Article 7. And in those circumstances, for that trial judge to find that human trafficking did not amount to a crime against humanity was erroneous. And that is a second indicator of a lack of impartiality of that judge. In relation to the second limb of the test set out in Article 20, subsection 3b, that is that there was a lack of bona fide intent to bring the defendant to justice. In the Al-Sanusi case, this lack of bona fide intent was interpreted as being an egregious violation of rights which facilitated the evasion of justice. The prosecution submits that the violation of rights was the lack of impartiality of the trial judge, and that the evasion of justice was the acquittal of the defendant, which was not appealable. And so the prosecution submits that the second limb of that test set out in Article 20, subsection 3b has been met, and that therefore the full test as set out in Article 23b applies, that being a lack of impartiality and a lack of bona fide intent to bring the defendant to justice. And in those circumstances, the exception to the principle of nebis in idem has been met, and this case is admissible. Mr. President, Your Honours, to conclude, in the preamble of the Rome Statute, the state parties agreed to be obligated to ensure the effective prosecution of the most serious crimes and ensure that they do not go unpunished. In order to ensure the effective prosecution of the conduct herein, this court must recognise human trafficking as a distinct crime against humanity in its own right. This court should allow Little Fingers Incorporated to be held to be an unindicted co-perpetrator for the purposes of prosecuting the defendant. And finally, this court should allow this case to proceed in circumstances where the exception set out. I note that I've just run out of time, Mr. President. I wonder if I might finish my sentence.
Yes, leave is granted.
Thank you. This court can continue to prosecute the defendant in circumstances where that exception to Article 20, subsection 3b is met. Unless I can be of any further assistance to the court, that concludes the submissions for the prosecution.
Thank you.
Please, court.
Thank you, Madam Prosecutor. If I could now hear from counsel for the victims.
May it please the court, Mr. President, Your Honours, today I appear before this court to represent over 10,000 Saudi migrant workers who are victims of human trafficking. These victims, some of them as young as 13 years old, have already been failed twice in their quest for justice. First, by the profit-hungry corporations for failing to improve their working conditions despite express promises. And second, by the farcical trial of the defendant conducted in the domestic court of North Ross. Your Honours, today I bring to you the lived experiences of these victims with the hope that this court will provide recognition to their sufferings and pin liability on those who are most criminally responsible. Through the course of my submissions, I shall be making three primary arguments. First, concerning the subject matter jurisdiction of this court, regarding recognition of human trafficking under Article 7(1)(k). Second, concerning the treatment of Little Fingers as an unindicted co-perpetrator. And third, regarding the admissibility of this case under Article 20, paragraph 3. Your Honours, moving to my first argument, I shall be dealing with two issues raised by defense in submitting before this court and trying to provide a different perspective in why this crime deserves a separate and distinct recognition from the crime of enslavement as contended by defense. And second, that the injuries, both mental and physical, in the present case rise to the similar level of severity as recognized under Article 7(1)(k). But before that, Your Honours, let me dispel the narrative that these contracts were entered voluntarily. Your Honours, the defense concedes that the definition of human trafficking is one which is given in the Palermo Protocol, which requires three conjunctive elements of the actions, the means to obtain the consent, and their purpose of exploitation. In the facts of the present scenario, Your Honours, we submit that the conditions of workers due to the economic depression in their own countries was such that they were in a position of vulnerabilities, which was then exploited by the shrimp shed operators from Westeros. Your Honours, we submit that subsequent part, Article 3b of the Palermo Protocol states that where the consent has been obtained through such an abuse of vulnerability, it would be irrelevant. Therefore, Your Honors, this court needs to assess the conduct in light of such an exploitation, and consent and the voluntary aspect which the defense wishes to highlight should not be given due weightage. Your Honors, moving to my first argument on why this deserves a separate recognition as an other inhumane act. The defense counsel relied on the drafting history on the Italy proposal in the Women's Caucus to recognize human trafficking as a distinct crime. And it was rejected, therefore, they proposed that that's the limited extent to which the Rome Statute drafters wanted to recognize it. We humbly differ on that, Your Honors. Your Honors, in 1998, when the statute was being drafted, the understanding of human trafficking was very different. It was primarily confused with illegal migration and sexual slavery. The Palermo Protocol, whose definition the defense has accepted to be authoritative, came into existence in the year 2000, which added distinct actus reus in form of the act, including transportation, recruitment, and harboring, the means element of obtaining the consent and the purpose of exploitation. Your Honors, the defense counsel primarily relies on the mention of the word trafficking in explanation to enslavement in Article 7.2c. And if I may invite this court's attention to Article 7.2c. Article 7.2c explains enslavement, saying it means exercise of any or all powers attaching to rights of ownership. Your Honors, the actus reus which is criminalized is the exercise of such powers attaching to rights of ownership. And in the subsequent line, it states that this also includes within its ambit such an exercise during the course of trafficking. In our submission, Your Honors, trafficking is an indicator of enslavement, and as Professor Anne Gallagher puts it, a vehicle for enslavement. But the actus reus of trafficking, as already submitted, has two materially distinct elements which are not subsumed within the crime of enslavement. And Your Honors, to capture the true extent of the victim's sufferings, in extracting them and forcing them away from their families for a prolonged period of 3 years. And secondly, by abusing their position of vulnerabilities when they sought to improve their working conditions or their life conditions. These are the elements which are not subsumed within any of the other preceding paragraphs. Second, coming to my second argument, Your Honors, with respect to the severity of injuries. Now, the defense counsel laid down different acts which are carried out as a part of the standardized contracts. For instance, retention of passport, the long working hours, and the severe control which is exercised on the lives of these migrants by controlling even their lodging and food conditions. But they did not provide us the standard against which this has to be measured. In their memorial, they agree that the standard to measure serious injury is that which is highlighted in the Christic and the Akayesu judgment, which is it should go beyond temporary unhappiness, and it should impair an individual's ability to lead a normal and constructive life for long-term purposes. Your Honors, here are the factors which demonstrate that there are both physical and mental injuries which does exactly the same thing to these victims. For instance, Your Honors, these workers are made to work for 80 hours a day, 80 hours a week, which is double the permissible guidelines by the ILO. Your Honors, this is coupled with the fact that shrimp shed industry necessarily involves that they dip their hands in ice, freezing water, which causes them frostbites. The bacteria then enters through the wounds caused by the frostbites and causes several musculoskeletal diseases and infections. Your Honors, because of the highly repetitive nature of the shrimp shed industry, for such a prolonged period of time, their muscles and bones get deformed. Your Honors, they also attain a higher risk of cardiovascular diseases. There are additional elements of respiratory diseases such as asthma, bronchitis associated with these conditions. This is coupled with the moral and mental impact by retention of passports and identification documents. Your Honors, that severely impairs the right to freedom of movement and the right to liberty to make any constructive changes to their lives, since they're only in effect given 1/5 of the wages they earn. Your Honors, these workers are trapped in a position of limbo where they cannot move away from the sufferings which they go through, and neither can they make any changes to the betterment of their lives because they are trapped by these shrimp shed operators. Your Honors, if I've satisfied you on the two questions here, on the first issue, I seek permission to move to my second argument. Thank you, Your Honors. Your Honors, the second argument concerns the treatment of Little Fingers as an unindicted co-perpetrator. If I may invite this court's attention to Article 25(3)(a), and here the wisdom of the Rome Statute drafters needs to be appreciated. They give recognition to the concept of indirect perpetrator, that is an armchair perpetrator who sits comfortably within his offices but still can direct the commission of crimes on the grounds. In fact, Your Honors, in the present scenario, the defendant MacGregor Clegane sits in the comforts of his offices in the capital city of Somerfell in North Ross, but directs the commission of crimes in West Rossi soil through the instrumentality of Little Fingers, which is a corporation. Your Honors, we recognize that the Defense Counsel has raised several drafting history arguments with respect to concerns regarding recognition of corporate criminal liability. Your Honors, while we clarify that today our case is not to extend jurisdiction of this court to the corporation, which is clearly limited by Article 25(1). However, we invite this court to look at several competing concerns and information which comes from the drafting history. The reason why the corporate criminal liability within the jurisdiction of this court wasn't recognized, as some authors put it, because of lack of political consensus and time. In 2 weeks, they were expected to agree to the nuances of how to attribute such liability. And in order to build a wider consensus, this was kept away from the jurisdictional limits of Rome Statute. Your Honors, we submit, however, that an individual can still use the instrumentalities of such organizations to commit the crimes. In the facts of the present scenario, similarly, the individual who's a natural person is up for indictment and not the Little Fingers, which is a corporation. And we wholly agree with the prosecution when they say that this assessment of conduct for effectively prosecuting the defendant, who's a natural person, does not amount to an exercise of jurisdiction, since exercise of jurisdiction is defined by this court's ability to make findings which are binding on the accused. Your Honors, therefore we submit that according an unindicted treatment does not fulfill that. Your Honors, on the second aspect which was raised by the defense counsel, that there is no control of the crime. We disagree on that, Your Honors. We submit that there are two ways in which Little Fingers is having and exerting control on the commission of crimes. Your Honors, Little Fingers provides 60% of the market for these shrimp shed operators to sell their product. And they in turn source their entire 100% of product from these West Rossi shrimp shed operators. They provide the reason why the crime is committed, that is, the provision of cheap shrimp. And they also provide the means to keep the prices cheap by funding the commission of this crime. Your Honors, on page number 4 of the fact sheet, you will note that this is an intensely financial crime wherein at the outset there is several heavy financial expenses which are incurred by these shrimp shed operators in arranging the travel processing fees, in arranging the transportation, in arranging all the permits. And this money is sourced through the corporations like Little Fingers, who have an active and complicit interest in keeping the prices of the shrimps low. Your Honors, also we submit that there is a compelling policy reason for this court to accord such unindicted treatment. For instance, Your Honors, if this court refuses to consider the conduct of a corporation through which a natural person has operated, in future, all individuals who wish to commit such serious crimes will merely incorporate a corporation and hide behind the corporation to commit the crime. And since this court would have set the precedent that it cannot adduce evidence or assess the conduct of the corporation, it would be rendered ineffective in exercising its jurisdiction over those individuals.
Counsel, the question I have is you've mentioned corporate criminal responsibility. Can you provide the bench with any examples of domestic law, international law, of relevant circumstances, and whether this is an idea that's now what's its position under customary international law?
All right. Thank you so much, Your Honors, for your question. Your Honors, back in 1998, when the Rome Statute was being drafted, there were differences, and because of concerns of complementarity, since some of the parties didn't recognize corporate criminal liability, it was excluded. However, in the last 20 years, and this is a noted observation from the prosecutor versus New TV case by the Special Tribunal on Lebanon, in exercising its contempt jurisdiction, it notes that over the past 20 years, there has been a shift in recognizing corporate criminal liability. Your Honors, various countries recognize that if a corporation commits crimes, and especially crimes of such grave magnitude, the corporate wheel could be pierced to hold an individual accountable. Your Honors, in the facts of the present scenario, for Rome Statute's purposes, though we do not recognize a separate legal personality in a corporation, we can still notionally pierce an organizational wheel to hold an indirect perpetrator liable, which is what we ask this court to do. Your Honors, if this court is satisfied on my second issue, I seek permission to move to my third argument.
Counsel, I do have one question. You're advocating for an evolving interpretation of the Rome Statute. How does that sit with the principle of legality and the principle of nullum crimen sine lege?
I understand your question, Your Honors. Your Honors, the evolving interpretation, as we may call it, has already been given its shape in the court's decision in Katanga in confirmation of charges, where in paragraph 498, the court recognized that an individual can commit crimes through another person. This might be an individual or an organization. Your Honors, this evolutionary interpretation, as we call it, is not with respect to the elements of a crime or a definition of a crime. This is with respect to realistically assessing how an individual can go ahead and commit crimes. Your Honors, and I do not ask this court to accord an evolutionary interpretation. I merely find the place of such an unindicted treatment within the existing four corners of the statute in the indirect perpetration. And this court, through its practice in Katanga, has already given that recognition to this concept. Your Honors, moving to my third issue, if there are no further questions on the second argument. Thank you, Your Honors. Your Honors, we recognize that Article 20, paragraph 3 bars a subsequent trial before this court if it has already been tried at the domestic level. However, we submit that a state cannot use the facade of legal proceedings to frustrate its ends of justice. Your Honors, we submit that in the present scenario, the erroneous interpretation under the circumstances of this case, which is what the agenda for this court is, it is not to evaluate that an erroneous interpretation stand alone will give this court the jurisdiction or the ability to admit this case. It's under the facts and circumstances of the present scenario. We submit that it falls within the second exception to Article 20, paragraph 3, wherein the proceedings lacked independence and impartiality, and they were conducted in a manner which in the circumstances was inconsistent with the intent to bring the person to justice. Your Honors, while we state that, we also ask this court to note that while assessing a state's intent behind committing a particular proceeding, the instances of direct evidence will be highly improbable. This court has to build the case by considering the circumstantial evidence which surrounds the case. And here are the factors which exist in the facts of the present scenario. First, Your Honors, is important to note the standing of the defendant in the society. The defendant, McGregor Clegane, is an extremely powerful and wealthy businessman. In the past, he has funded the political campaign of a former president, establishing political connections which last far longer than the terms of an existing president. Your Honors, he is an individual who wields immense political power in the country. The second factor is to note the individual who's presiding over his case. Judge Nefarious was appointed in the year 2011 when the former president, whose campaign was funded by this individual, came to power. He was appointed for a term of 8 years. Your Honors, he's presumably up for reappointment in 2019. And if not reappointment, then certainly some other job. Your Honors, this specific scenario has to be coupled in the manner in which the proceedings were conducted. Your Honors, the prosecution noted that this was a mere dismissal on lack of exercise of jurisdiction. We bring to this court's attention a second more important fact. Your Honors, while we can understand, if assumably, that a judge can hold human trafficking to be an ordinary crime, in the second charge, where the defendant McGregor Clegane was up for aiding and abetting charges, the judge held that due to lack of extraterritorial application of the domestic statute, we cannot hold him accountable. However, Your Honors, the cause of action, which is aiding and abetting, arose within the domestic jurisdiction of the North Ross District Court. And therefore, coming to the conclusion that he cannot exercise such extraterritorial jurisdiction, itself further reveals a larger intent in the scheme of things which we have already laid down before this court, that there was an intention inconsistent with the intent to bring the person to justice. Your Honors, this has to be now appreciated by the standard laid down by the Al-Senussi and the Furunzija case, that impartiality has to be assessed from the standpoint of a reasonable observer, an individual who is aware of factual circumstances and scenarios. Your Honor,
Counsel, I understand the point that you're trying to make, but before accusing a sitting judge of a domestic court, should this court not require something a little more concrete? The error of law argument that you're providing, could that not just down to be a legal interpretation issue?
Your Honors, we recognize that that might be the case. However, if I may invite this court's attention to the agenda before this court. Your Honors, the agenda lays that the erroneous interpretation of ICC statute's definition of crimes against humanity, and this is the important part, if I may just complete this sentence.
Yes, you have leave for another minute.
Under the circumstances of this case, we do not submit that an erroneous interpretation by itself makes this case admissible. But this erroneous interpretation, backed by the fact that the defendant is extremely a wealthy and powerful individual, and the judge would presumably be prone to succeeding to such a pressure by an individual, in light of the fact that the newspaper report by a journalist represents the perception of a reasonable observer who's aware about these facts and circumstances. Your Honors, if I may conclude my pleadings, it is our submission before this court that because the crime of human trafficking has additional materially distinct elements, and that it is an odious practice, this court must distinctively recognize it as a crime against humanity under 7(1)(k). Second, to effectively prosecute the defendant, the court must treat Little Fingers as an unindicted co-perpetrator. And third, this court may admit this case. Thank you so much, Your Honors. It was an honor.
Right. Thank you, Mr. Counsel for the victims. Well, both parties and the counsel for the participant have raised important issues, and I think it merits a rebuttal. And in the same order that you presented your submissions, I will invite first the defense. You will each be given 10 minutes.
Mr. President, Your Honors, the defense will be making 4 points in rebuttal. Now, the first point relates to issue A, the second and third relates to issue B of the appeal, and the last point will relate to the issue C of the appeal. Now, at the outset, we do not wish to downplay the difficult working conditions of the South migrant workers. But, Your Honors, the critical question before this court today is whether difficult working conditions suffered by the South migrants is serious enough to amount to crimes against humanity, and whether it is prejudicial to my client to charge him for the most heinous charge of crimes against humanity. And with this, I turn to my first point in rebuttal. This relates to whether great suffering has been made out. We note that the prosecutor and the victim's representative have similarly applied the decisions of Kristich by the ICTY and the case of Akeyasu by the ICTR in setting out the threshold that there must be grave and long-term disadvantage to the victims. However, in the present case, the difficult working conditions have not shown that the victims had the working conditions had resulted in serious and long-term disadvantage. The inhumane acts, as recognized by this court thus far in the cases of Muthara, have recognized serious bodily mutilation and penal amputation to amount to that threshold. In the case of Ongwen, this court recognized that forced marriage is a crime under Article 7.1k, noting that the victims suffers serious social stigma even after leaving the conjugal union. Your Honours, in the present case, however, the prosecutor has not adduced any evidence to show that the victims had suffered such serious and long-term disadvantage. While we note that the victim's representative have adduced reports to the effect that the working conditions of shrimp peelings might result in certain serious long-term suffering, but we must note that the reports adduced have not considered the specific factual matrix of the Saudros migrants. These reports relate to shrimp peeling industry in the Thailand shrimp industry and do not relate to the facts of the present case. As noted by the Muthara case confirmation of charges decision at paragraph 279, that even at the stage of confirmation of charges, the prosecution must show sufficiently compelling evidence which goes beyond mere theory or suspicion, at paragraph 37 of the decision. Now, the present case is similar to the Muthara confirmation of charges decision case, which this court refused to confirm the crime of Article 7.1k. Now, in that case, the prosecutor alleged that the destruction of homes and property amounted to crimes against humanity. But similarly, in that case, given the lack of the intensity of suffering of the victims, the court refused to confirm the Article 7.1k charge. Your Honours, I now turn to my second point in rebuttal, and this relates to whether Littlefingers on the facts can be treated as a co-perpetrator. The prosecutor has cited the Lubanga decision at paragraph 1003 to 1005 for the test that a co-perpetrator must possess control behind the direct perpetrators of the crime. Now, Mr. President is earlier concerned as to whether Clegane or Littlefingers had possessed such control and queried the prosecution on this point. Now, to this end, the prosecutor relied on page 5, paragraph 2 of the Northeros trial court decision that stated that Clegane had the ultimate authority to disapprove and block the actions of Littlefingers. Your Honours, this reliance is misplaced. Now, given that the question before this court is not whether Clegane exercised control over Littlefingers, but whether Clegane exercised control over the shed operators and therefore had a say over how the shed operators treated the migrant workers. Now, in the present case, we state that the usage, the low prices by the Littlefingers in purchasing the shrimps is not sufficient to make out the control of the crime in Westeros. Now, furthermore, we note that the prosecutor has argued that there are evidence on the facts of the present case that give rise to knowledge and perhaps intention on the part of Clegane and Littlefingers as to the conditions that the Saudros migrants were subjected to. However, Your Honours, co-perpetration is no longer relying on the subjective approach. The joint criminal enterprise approach, as was taken by the ad hoc tribunals, was not adopted by this court in the Lubanga-Katanga decision. While in the past, a perpetrator might be liable under a joint criminal enterprise if he possessed the intention, under the current approach of co-perpetration as set out in the Lubanga and Katanga decision, there is a strict requirement that there must be control. Mere knowledge or intention is not sufficient to render a perpetrator liable under Article 25.3a of the Rome Statute. Your Honours, I now turn to my third point in rebuttal. This relates to whether we should take a progressive interpretation as to Article 25, paragraph 1 of the Rome Statute. Judge Singh was earlier concerned with whether domestic domestic jurisdictions are increasingly recognizing the concept of crimes against humanity. And to this end, the victims' representative have rightly pointed out that there are increasing number of states recognizing the concept of corporate criminal liability. However, Your Honours, we submit that this point is of no bearing in the present case. As was stated in the Travaux Préparatoire, the state parties rejected any reference to the concept of corporate criminal liability because there was no universal definition in relation to the rules of attribution. Now, therefore, the fact that more state parties are recognizing corporate criminal liability does not mean that there is a universal definition, and the concerns of the state party is still engaged. Now, moreover, Your Honours, we submit that the fact that all these state parties require express legislation in their domestic law in order to prosecute crimes committed by corporate entities go further to show that in order to treat Littlefingers as a co-perpetrator, even where unindicted, requires express provision within the Rome Statute. And earlier, Judge Alberto was queried the victim's representative as to whether the principle of legality as provided under Article 22 has been infringed. And we say that in treating Littlefingers as a co-perpetrator, even where unindicted, infringes this principle on two grounds. Now, first, Article 22(1) states that in order for a crime to be prescribed, it must require express provision. Now, in Article 23, paragraph A, it only states persons, but not legal persons. Now, therefore, that provision cannot be applied to Littlefingers. And furthermore, under Article 22, paragraph 2, it provides that if there is ambiguity as to the provision, now in this case, there might have been some ambiguity as to what constitutes person and whether it includes legal persons. Now, in line with Article 22(2), the more favorable interpretation must be accorded to my client. In view of the time, Your Honours, but before I move to issue the last issue of the appeal, earlier I also note Judge Singh queried the prosecutor as to whether Article 28B can be applied to companies. And we note that it cannot because Article 28B provides for the word subordinates, and there's no available jurisprudence both by this court and the ad hoc tribunals that recognize subordinates, that recognizes legal persons as subordinates. And we have penned written submissions on page 837 in our written memorandum, and in view of the time, I will defer to my written submissions in that regard. Now, Your Honours, I shall now turn to the last and final point of rebuttal relating to the issue of admissibility. We note that the prosecutor and the victim's representative have argued at length that the error of law, as rendered by Judge Nefarious, would allow this court to intervene. Now, Judge Singh earlier was concerned with whether an error of law is in fact a different interpretation taken by another judge. Your Honours, this is precisely what we are arguing here, that judges do differ in terms of their interpretation of the law. If we refer to the pre-trial chamber below, the decision below, we note also that it was not a unanimous decision. As stated on page 8, Judge Vexatious had in effect reached the same decisions as Judge Nefarious. Now again, we submit that if we allow this court to intervene whenever it reaches a contrary interpretation from the domestic court, it will completely render the principle of complementarity unworkable. Now, in closing, it is important that the charge against my client, be dismissed. Now, because the decision by the pre-trial chamber below has shaken the very foundations of this court, exceeding the ICC's jurisdiction and severely undermining the principle of complementarity. Now, not only does this infringe on the due process rights of my client, but the pre-trial chamber has set this court on a worrying course of development that may potentially undermine its legitimacy among state parties. And in this regard, the defense humbly prays that this appeals chamber must act now and set aside the charges against my client. Unless I may be of further assistance to this court.
No, thank you very much, Mr.
This concludes my submissions. May it please
Counsel
the
for
court.
Defense. Madam Prosecutor.
Mr. President, Your Honours, may it please the court. I have 5 points to make by way of rebuttal in response to the defence. The first is that great suffering in present circumstances has been made out on the threshold required by the pre-trial chamber. The second is that the co-perpetration test in relation to control has been made out, and that the requirement does not relate to control of the independent shrimp sheds themselves. The third is that the prosecution is not seeking to ask this court to take a progressive interpretation of Article 25. The fourth is that Article 28b, in the present circumstances, does apply where it has not been appealed. And the fifth is that the prosecution are not seeking to have this court intervene on the basis of an error of law. Moving to the first point, and that relates to the great suffering in the present case. The court will note from Article 61.5 of the Rome Statute that at the pre-trial chamber stage, it is only necessary for the prosecution to establish the conduct in question on the basis of substantial grounds. The defence has contended that insufficient evidence has been proffered in relation to this great suffering. However, the court will note from that provision in 61.5 that at the pre-trial chamber stage, it is not necessary for the prosecution to call witnesses, and this court can rely on the findings of the pre-trial chamber during the course of its assessment as to whether or not great suffering has been made out. And again, the prosecution would point to the circumstances of the conduct, that being the long working hours, the isolation, the deduction of over 80% of their wages plus interest, and then the evidence submitted during the course of the Westeros trial. In relation to my second point, counsel for the defence contends that the test for co-perpetration is not met because it has not been established that the defendant had control over the owners of the shrimp sheds in question. In fact, that is not the test with which this court is concerned. This court is concerned with whether or not the defendant and Littlefingers Incorporated had control over the conduct in question. That conduct relates to their essential contribution to the human trafficking which occurred in those shrimp sheds. And as previously stated in my initial submissions, in circumstances where the defendant had knowledge of the conduct in question and did not act on that knowledge and continued to purchase shrimp from 2015 onwards, knowing that the abusive labour practices were taking place, in those circumstances it cannot be said that that conduct cannot be assessed by this court and that control over that crime was not in the hands of Littlefingers Incorporated and the defendant.
Counsel,
Yes, Your Honour.
I'm a little bit confused. Are you alleging now that there was either control over the conduct in question or there was knowledge of the conduct in question? Because the two, I think, are a little bit different.
Yes, Your Honour. My apologies if I have misled the court. In fact, I'm stating that there was knowledge of the conduct in question, at least from 2015, on behalf of Littlefingers Incorporated and the defendant, and that even in the knowledge of those abusive labour practices, they continued to purchase the shrimp. And so that conduct was in furtherance of the human trafficking which occurred in those shrimp sheds. And in those circumstances, it can be held that Littlefingers Incorporated and the defendant had control over the criminal conduct in question. Moving to the third ground, and that is this alleged progressive interpretation of Article 25. Again, counsel for the defence refers to the drafting of the Rome Statute and the rejection of criminal corporate liability by those parties. The prosecution is not seeking to hold the parties liable. To hold Littlefingers Incorporated liable. We are merely seeking to prosecute the defendant. We are not going against the intention of the drafters. We are simply attempting to prosecute the defendant for his conduct in the course of the trafficking of the South Row citizens. And in those circumstances, we are not asking the court to extend this jurisdiction to corporations. My fourth point in relation to Article 28b relates to the fact that the defendant states that corporations cannot be assessed in Article 28b. In fact, the court will note that the grounds of appeal before this court do not relate to Article 28b. This ground has not been appealed. This finding was made in the pre-trial chamber stage, as noted in paragraph 1b of the pre-trial chamber's confirmation of charges. And so any arguments in relation to Article 28B cannot be pursued at this point, but can only be pursued during the course of full trial. Finally, counsel for the defence contends that an error of law cannot allow this court to intervene. Again, the prosecution must emphasise that we are not seeking to have this case admitted on the basis of an error of law. We are seeking to have this case admitted under Article 20, subsection 3b, wherein it states that where there is a lack of impartiality on behalf of the initial trying court and a lack of bona fide intent to bring a defendant to justice, then that is an exception to the ne bis in idem principle. And the prosecution submits that that threshold has been met in the present circumstances, and so this case can be admitted. One other matter which arose during the course of the submissions of the victims was the voluntary or alleged voluntary nature of the contracts in question. And the prosecution supports the contention of the victims that the Palermo Protocol does state that where there is an abuse of power or vulnerability, that conduct can still be considered to be human trafficking. And it is submitted on behalf of the prosecution that that principle of exploitation on the basis of economic vulnerability has been recognised in the UN model law, has been applied by numerous Supreme Courts, including the Netherlands, Moldova, and the UK. And in fact, in one case in Oran Khan in the UK, when applying the model law, the court found that even in circumstances where the victims left the jurisdiction in which they were subject to abusive labour practices, returned to their home, they subsequently returned to those abusive labour practices, that still amounted to human trafficking because of their grave economic circumstances. And so any question in relation to consent to these contracts in the prosecution's submission does not arise. That concludes my submissions, unless I can be of any further assistance to the court.
Thank you, counsel.
May it please the court.
Well, that leaves the last word for counsel for the legal representative for the victims.
Thank you, Your Honours. Good afternoon again. Through the course of my proceedings, I shall be making 4 primary points of rebuttals. The first and second concern with issue 1. The third concerns with the issue 2. And the last one dealing with issue 3 before this court. Your Honours, proceeding with the first rebuttal, in response to the defence contention on great suffering, they quoted examples from the Ongwen and Mathuara case, wherein they stated that a conduct where there were forced shootings and starvation of victims and making the victims watch their close family members being shot was something which was held to meet the threshold of serious suffering or grave injury. Your Honours, however, we submit that has no bearing that independently in the facts of the present scenario, that the conduct can also rise to the same severity threshold in line with the legal standard given by Christic, which causes an impairment for these victims to lead a normal and constructive life for a long-term purposes. And through the course of our main proceedings, we had demonstrated before this court, and this is documented in several ILO reports, that the workings in these circumstances specific to shrimp shed industry, coupled with long working hours, invariably ends up causing physical harm and bodily harm to these victims in forms of the musculoskeletal and cardiovascular diseases, which will impair their ability to lead normal and constructive lives even after the 3-year contract period for which they work. Your Honours, secondly, on the point that there is no documented evidence, we agree with the prosecution on the burden of proof. And secondly, we state before this court that there already exists in form of 1,000-page witness testimony and documentation the injuries as examined by the Westeros District Court, after concerning which the court reached to a conclusion that $20 million damages were worth awarding to the sufferings of the victims. We submit that on the prosecutorial standard of burden and the real injuries which will occur necessarily by retention of passports in the form of mental harms and the physical injuries which the representative of victims submitted. This case at least deserves to go to trial so that this court can examine the true nature and extent of the sufferings and their severity as per Article 71K. Your Honor, coming to my second issue and the primary point of rebuttal, wherein the defense contested that Little Fingers or the defendant does not have control over the shrimp shed operators. And the prosecution rightly pointed out that this is not with respect to the control over the other party, but with respect to the commission of crimes. And the definition is as such, that if one party refuses to perform their end, the commission of the crime would be frustrated. We have demonstrated before this court, Your Honors, that if Little Fingers refuses to perform its end, the 60% market and the huge funding which Little Fingers provides will ensure that this crime cannot sustain on the economies of scale which it does right now, which makes the cheap labor profitable for these companies and the shrimp shed operators to exploit these victims. Your Honors, we also submit that on the second issue, in recognizing an unindicted treatment of a corporation, this court will vindicate the claims of victims, as the victims and their families have a right for true and accurate facts be recorded in understanding the circumstances of the injuries which are caused to these victims. We therefore urge this court to grant that unindicted treatment so that the true circumstances and the manner in which these atrocities were committed on these victims can be documented. Your Honors, moving to my last argument, which concerns the point which defense counsel made in terms of erroneous interpretation of law. And to substantiate that, they cited that in the preceding pre-trial judgment, Judge Vexatius also differed. Your Honors, our submission before this court is not that the end result matters. It's the process which was followed, in the circumstances that process was followed is to be looked at to determine the quality and the intent behind the end result. Your Honors, Judge Vexatius' decision was appealable if he had passed that, and we clearly are in appeal before this court. However, the judge nefarious, he knew that an acquittal in his country is non-appealable, and therefore further demonstrates that a poorly reasoned judgment which takes away the right for anyone to appeal reveals a larger intention to shield in light of the context in which this erroneous interpretation occurred. We recognize, Your Honors, that an erroneous interpretation by itself is an impossible burden for the prosecution and victims to satisfy. Therefore, we invite this court's attention to the surrounding circumstances and the manner which we submit falls within Article 23B was inconsistent with the intent to bring the person to justice. Your Honors, we submit before this court that this case at least deserves to go to trial. It is in paramount interest of the victims that their injuries are recognized so that they are enabled to claim reparations before this court under Article 75. Your Honors, for the victims, this is the last resort. And we therefore submit before this court in light of the submissions we have made and in light of the rebuttals that this court confirms the charges against the defendant and sends this court to trial. It was an honor to represent the victims before this court today. If I may not be of any further assistance to this court, I conclude my submissions.
Thank you very much, Counsel. The Chamber has received cogent, compelling, and convincing submissions from both parties and the participants. You have given us some challenge. The Chamber will have to retire to consider where we are. We will return at 16:45. What I will say is that The submissions have been extremely good, extremely helpful, and we shall rise and return at 16:45.
All rise.